Thank you so much, Kelly, and thanks to everybody who's joining today. I am happy to hear that a bunch of people registered for the webinar, and I hope that you all find it useful. There are many questions within immigrant communities, immigrant families around this issue. People are really afraid and very confused. So I am hoping that you all get some good information from this webinar that you can pass along to your clients who are asking questions about how public charge might affect them. Please use this phone number and email address. If you have questions about public charge, I'm happy to help you all think through questions that you get. And as a reminder, if you haven't been getting questions yet, you might get them soon. The State Department of Human Services sent out a letter to everyone in a family that includes at least one non-U.S. citizen who are also receiving public benefits. Sent them a letter about public charge. The letter was meant to encourage people to help them feel safe to continue to get public benefits. But as you might imagine, for many people, it has raised more questions than it answered. So at CLS, we've been getting a lot of calls in response to the letter, and you all might start getting those questions as well. So let's get started. It is indeed October 17th, not October 16th, as this first slide indicates, but just in case you were wondering, it is the 17th. But let's get started. We have a lot to cover, and I do want to save time for your questions, so please remember to ask them along the way as they come up. So public charge is a part of federal immigration law that has been a part of federal immigration law for a very long time, since 1882. And public charge operates in immigration law in a couple of ways. One of the things that it does is it creates this public charge grounds of inadmissibility. And under that public charge ground of inadmissibility, immigration officials can deny some people a visa or a green card if that immigration official finds that the immigrant is a public charge. A few really key pieces of information just from that first slide. The first is it's just about visa and green card applications. It's not about anything else. So public charge cannot be used to deny a U.S. citizenship application. So if people who already have their green cards, typically the next step for them in their immigration cases is a U.S. citizenship application. Public charge cannot be used to deny people U.S. citizenship. It also cannot be used to strip people of U.S. citizenship if they have already naturalized. It cannot be used to deny green card renewals. So once somebody gets a green card, the card is good for 10 years, and after 10 years, you have to renew the card. Public charge is not part of the green card renewal process, so public charge cannot be used to deny somebody a green card renewal. Public charge also is not part of the asylum application process. People cannot be denied asylum on public charge grounds. DACA, Deferred Action for Childhood Arrivals, these are our dreamers. DACA still exists. The Trump administration attempted to end DACA, but they are under court order to keep it in place. So people who have DACA can continue to renew it and cannot be denied a DACA renewal on public charge grounds. Public charge is not part of the TPS application process. TPS is temporary protected status. Every once in a while, the Department of Homeland Security might designate a country as too dangerous to deport people back to, and that country will get a TPS, a temporary protected status designation. So people who are here in the U.S. from those countries, when the TPS designation goes into effect, can apply for this temporary protected status, which allows them to remain in the U.S. lawfully, work here, and be protected from deportation. So, for example, Haiti got a TPS designation after the 2010 earthquake, and that designation is still in place. So people sometimes are here for decades and decades with TPS. You have to renew TPS every 18 months or so, so those TPS renewals cannot be denied on public charge grounds. VAWA petitioners, VAWA is the Violence Against Women Act. VAWA does a bunch of things. One of the things it does is it tells people who are eligible for a green card through a spouse. So if somebody's married to a US citizen or a green card holder, they sometimes can apply for a green card on a petition filed by their spouse. But if that spouse becomes abusive, VAWA says that the green card petitioner, the potential green card petitioner in that relationship, can separate from the abusive spouse and apply for their green card on their own. They don't have to stick around and endure the abuse just to get the green card that they are otherwise eligible for. So public charge cannot be used to deny someone VAWA petitioner status. UNT visas cannot be denied for public charge reasons. U visas are available to victims of crime, usually violent crime here in the US. T visas are available to victims of human trafficking. And then also special immigrant juvenile status cannot be denied on public charge grounds. Special immigrant juvenile status is available to many of the unaccompanied minors coming up from Central America. So that's a lot of people right off the bat who are safe from public charge because public charge just is not part of their immigration case. In addition to all of that, there are some people who, when they go to apply for the green card, they are exempt from public charge. So, you know, public charge typically applies during the green card application process, but there are lots of people who are exempt from that public charge grounds of inadmissibility when they're going to get their green cards. Refugees arrive in the US with their refugee status in place. Typically the first thing they do in their immigration case is apply for a green card. They cannot be denied green cards on public charge grounds. People who have been granted asylum can get a green card as an asylee. They cannot be denied a green card because of public charge. VAWA petitioners cannot be denied green cards on public charge grounds. Special immigrant juveniles, UNT visa holders, all cannot be denied green cards on public charge grounds. So who's left? So those first couple of slides kind of, you know, take care of a large portion. I don't know about you all, but for my immigrant client groups, many of them are exempt. You know, those first couple of slides takes care of most of them. But there is this one group of people who we are concerned about, and the main group of people we're concerned about are people who will be applying for visas or green cards on family petitions. So these are people who whose eligibility for a green card is based on a family relationship, so their spouse or their parent or their sibling is a US citizen or a green card holder and is applying for their family member to immigrate to the US and join the family. These are not people who already have their green cards that they received through family petitions. These are people who will be applying in the future for visas or green cards on those family petitions. There is also the small risk for people who already have their green cards and who are traveling abroad. Generally speaking, people with green cards can come and go into and out of the US without any public charge risk. But if folks leave for 180 days or more, immigration officials can presume that they have abandoned their lawful permanent residency. And so when folks try to come back, it's like they're starting all over again. And there might be a public charge issue that arises at that point. But as long as people are coming and going in less than 180 days, everything should be fine. So that's the main group of people that we're worried about. And so you note that this is a relatively small group. If you think about your immigrant clients and you think through, especially for folks in LSC restricted programs, you probably don't have many clients who are themselves applying, still in the process or thinking about applying for visas or green cards on family petitions. So it's a relatively small group of people who have this public charge risk. There are two arms of the federal government that make these public charge determinations. The Department of State makes them for people who are applying for visas and green cards from overseas. So these are people who are applying in their home countries for a visa or green card before they even get here to the US. And then the Department of Homeland Security, through USCIS, United States Citizenship and Immigration Service, makes these public charge decisions for people who are applying for visa renewals and green cards here in the United States. We are really focused on the USCIS Public Charge Policies because all of our clients are here in the US, right? We generally, as legal services providers in Pennsylvania, don't have clients who are not here in Pennsylvania in the United States. I am a public benefits attorney, right? And you cannot get public benefits in Pennsylvania unless you are here in Pennsylvania. So the Department of State process just simply does not affect our clients the way that the USCIS public charge policy has some real potential to affect our clients. So the current policy at USCIS around public charge has been in effect since 1999. It's still in effect today, and it's going to stay in effect for the foreseeable future. And what that policy says is that a public charge is someone who depends almost exclusively on the government for subsistence, as demonstrated by receipt of either cash assistance or long-term institutionalization at government expense. So somebody's past or current receipt of cash assistance or long-term care medical assistance used for nursing home admission can be considered when making public charge determinations here in the US. But that's it. No other benefits can be considered besides cash assistance meaning TANF, general assistance, and SSI. Or long-term care medical assistance, which is a very special kind of medical assistance that people can use to get into a nursing home. It's not the kind of medical assistance that people use to go see doctors or pick up prescriptions at the pharmacy. It's a very specific type of medical assistance that can be considered under this current USCIS public charge policy. Family members' receipt of benefits generally cannot be counted against the green card or the visa applicant. There's one exception to that rule. So if there's a family member who is receiving cash assistance and the family is using that cash assistance as the family's sole source of income, then that family member's receipt of cash assistance can be counted against the green card visa applicant that is subject to the public charge test. But in nobody's past receipt of any of these, either of these types of public benefits, either cash assistance or long-term care medical assistance, can alone make somebody a public charge. Everything about an immigrant is supposed to be taken into consideration. Their family support, the money they have in the bank, their education, their skills, their work history, all of that is supposed to be taken into consideration. It cannot be that just because somebody received TANF in the past, for example, that they are automatically a public charge. So that's the current policy, and like I said, it's still in effect today, and it will remain in effect for the foreseeable future because of these wonderful court orders that we got starting Friday and going through the weekend. To back up a little bit, on August 14th, USCIS published new rules redefining the term public charge. And then on October 11th, the Department of State followed, published its own rule redefining the term public charge in the same way that the August 14th USCIS rule redefined public charge. USCIS's new rules were scheduled to take effect a couple days ago on October 15th, but now that we have three or four different nationwide preliminary injunctions and one Pennsylvania-specific preliminary injunction in place, the new rules cannot take effect. So they've been blocked from taking effect on October 15th, and that block will stay in place until the these 9 lawsuits reached their ultimate conclusions. The Department of State changes are still in flux. There's a lot of confusing stuff happening on the Department of State side. So if you are working with somebody who will need to leave the United States to apply for a green card or visa and go back to their home countries to apply for a green card or a visa, or if you're working with a family who's trying to help a family member immigrate from overseas, those folks really should get in touch with an immigration attorney to talk about that Department of State public charge process, because it's very different than what's happening here in the US. So there are no changes being made for now for people applying for green cards or visas here in the US. And any changes that may be made in the future, so even if, you know, all of those 9 lawsuits fail and the new rules do end up going into effect, the new rules cannot be retroactively applied, right? So the new rules are in a place, and those are the only rules that can be applied to people's future green card applications, no matter when, as long as those green card applications are submitted before the new rule might take effect. And hopefully it'll never take effect. But it's really important to understand that the new rules, if they ever do take effect, cannot be retroactively applied, so people are safe for now. The very, very large majority of people are safe when it comes to public benefit access. Almost everybody who's eligible for public benefits in Pennsylvania can get those public benefits without any public charge risk. And hopefully this table helps you kind of visualize that. So everybody in green here is safe, right? They can go ahead, they have the green light to go ahead and get the public benefits that they might be eligible to receive. Because, as you'll see in that column all the way over to the right, they are not subject to USCIS's public charge rule. The one group of people who should kind of slow down and take a yellow light and think a little bit and talk with an expert before applying for benefits they might be eligible for are people who are applying for green cards on family petitions. And you'll note here that there are just 2 types of benefits that folks should slow down and think about, that group of people, those green card applicants on family petitions, there are just 2 types of benefits that they need to slow down and think about, right? Just cash assistance and long-term care medical assistance, right? Those are the only 2 benefits programs that both create public charge risk and that their immigration status will give them some potential access to. So I'm going to talk about that in a little more detail, hopefully to help folks understand that a little better. So I'm going to start with cash assistance, TANF and general assistance. These are the 2 cash assistance programs that we have in Pennsylvania. TANF is available to families with related children, pregnant women. General assistance, I know, was eliminated in August by the state legislature, but hopefully you all know that CLS is working very hard. We were just in the Pennsylvania Supreme Court yesterday. My colleague Maria Pulzetti was arguing there to get GA restored. So we're going to keep talking about it because we believe strongly that it's going to come back and it should come back. But you know, receipt of either one of these cash assistance programs is implicated under current USCIS public charge policy. So receipt of either of these cash assistance benefits could put people who have a future public charge test in their future at public charge risk, right? The grant amounts are very low. They have not changed since 1990s. People receiving cash assistance are living really in the deepest levels of poverty that we have here in Pennsylvania. I put this little note here in this red box because we get this question a lot here at CLS, and it does really confuse people. So cash assistance is issued on an EBT card to a person the household chooses as the payment name, right? So but the person who's the payment name may or may not be a cash assistance recipient. For example, an undocumented mother will not be eligible for TANF just because of her immigration status. But if her U.S. citizen children receive TANF, she may be the payment name for her children's TANF and have an EBT card with her name on it. But just because she has that EBT card with her name on it does not make her a TANF recipient. In this scenario, her children are the only TANF recipients, and she has no reason to fear that she will be deemed at some point to have received TANF for herself. She is safe there. Cash assistance is available to a pretty wide range of immigrants. There's no 5-year bar, so if you do any benefits work, you might have heard about this 5-year bar, this 5-year waiting period that a lot of folks have for a lot of benefits, but it doesn't apply to cash. And you'll note that people with pending family-based petitions for green cards are potentially eligible for cash assistance, right? So there is this group of people with some potential public charge risk whose immigration status will potentially make them eligible for cash assistance.
Maripat, before you go on to your next slide, I'm going to launch the first of the 2 polls for the CLE credits for the attorneys. So please go ahead and respond now. And we also have a question if you'd like me to read that to you right now.
Sure, yeah, that would be great.
Okay, it says for an immigrant on a family petition, is Section 8 housing an issue if they are living with citizen family members in a Section 8 housing project?
No, not under current policy. The only things that can be considered under current public charge policy are cash assistance and long-term care medical assistance. We're going to talk in a minute about what USCIS would like to include in their new rule. And the new rule would, if it ever takes effect, would include Section 8 housing subsidies. But if somebody's still applying for a green card on a family petition, they don't have the green card yet, they're not going to be eligible for those housing subsidies on their own. So their family members' receipt of those subsidies will still be fine, even under the new rule. And we're going to talk a little bit, like I just said, we'll talk in a couple minutes about the new, so hopefully that'll be clearer in there.
And we have one more question that just came in. Is it correct to understand that applicants for green cards who are not on family petitions are safe from the PC test?
That's almost entirely true. So the main group of people we're worried about are people who are applying for green cards on family petitions. There are some other groups of people who are subject to public charge tests. Diversity lottery winners, for example, are subject to public charge tests. That's the only other group that's coming to my mind right now. Technically, people who are applying for short-term non-immigrant visas are also subject to public charge, but because they're generally only here for short periods of time, it's much easier for them to pass the public charge test than for people who are applying for longer-term permanent immigration statuses.
Thank you.
All right. Do I have to close this poll, or?
You could just close it out. Yeah.
Okay, great. All right, so I put this chart up here just hopefully to help people visualize that the very large majority of people who can get cash assistance, whose immigration status gives them some eligibility, some access to cash assistance, will be safe. But there is this potential issue for people who are in that process of applying for a green card on a family petition. They should think about whether they want to receive those benefits, consult with an expert while making that decision. All right, the next benefit program that's implicated under current USCIS public charge rules is SSI. The SSI grant amounts are a little bit higher than the cash assistance grant amounts, but still pretty low to keep people under the poverty line. SSI usually is directly deposited into people's bank accounts, but again, just like with cash, Just because you are the name on the bank account where the SSI is being deposited does not make you necessarily the SSI recipient. So if, with the same example of an undocumented mother receiving SSI for a U.S. citizen child, just because her child's SSI is being deposited into her bank account does not make the mom an SSI recipient. In that scenario, it's still the child that's the only SSI recipient. It's really hard for immigrants to get SSI. There are very restrictive rules around immigrant eligibility for SSI. Most people have to become a U.S. citizen in order to get SSI. Cuban entrants can get SSI. Refugees, asylees, and T visa holders can get SSI during their first 7 years in the U.S. They are expected to get their green cards and then naturalize in those 7 years, and if they don't, they will be cut off of SSI. And then beyond that, it's very, very difficult. There are these tiny pockets of green card holders who potentially have some access to SSI, but I think maybe I've met maybe 2 folks who are able to meet these really tough standards for green card holders to get SSI. So most people who are either refugee or refugee-like outside of their 7 years, or people who have green cards, for most of those people, the answer will be you just have to become a U.S. citizen in order to get SSI. And note that people who have non-immigrant visas or who are applying for green cards on family petitions cannot get SSI. Their immigration status will make them ineligible right off the bat. So everybody for SSI is green here, because the people with public charge risk can't get SSI even if they want it, right? Their immigration status is going to make them ineligible. So they don't have any access to the SSI, so there is no kind of public charge risk for anybody who is getting or can get SSI. The last benefit implicated under current USCIS public charge rule is long-term care medical assistance used for institutionalization. So long-term care medical assistance is available to people who are eligible for regular MA and who also have a medical need for nursing level care. It's available to some people whose income and resources are a little bit higher than the regular MA income and resource limits. Long-term care medical assistance pays for nursing home admissions, and that is what current public charge policy implicates, right? So current public charge policy considers past institutionalization at government expense. So it really is about that nursing home admission. Long-term care medical assistance also pays for nursing services people receive in their homes and their communities, also known as home and community-based services. HCBS, home and community-based services, is not implicated in current public charge policy because it's not a nursing home, it's not an institutionalization. Long-term care medical assistance is not, the kind of regular medical assistance that people use just to go for doctor's appointments and to get medicine or go to the hospital or to get short-term rehab in rehabilitation facilities. So it is a very specialized type of medical assistance that is implicated in the public charge policy. Long-term care medical assistance is available to a relatively wide range of immigrants. This is a partial list, and you'll note at the bottom that it does include people with pending green card applications. So people with some public charge risk, potentially, do have access to some long-term care medical assistance used for institutionalization. The folks applying for green cards on family petitions should, like I said, with the cash assistance, slow down and think, consult with an expert before deciding to apply for long-term care medical assistance. These folks are going to be ineligible for federal long-term care medical assistance because of the 5-year bar and all of these immigration restrictions around immigrant access to federal medical assistance. These folks potentially have access to long-term care medical assistance for institutionalization through state-funded MA. But it would still be institutionalization at government expense, even though it's not federal government expense. I don't think that there's any relevant distinction between the government expense being at the state government expense rather than the federal government expense. So these folks should slow down and think before applying for long-term care medical assistance if they can. So that's the current policy as it applies today and as it will continue to apply for the foreseeable future, at least while this litigation plays out in the courts. The new rules that were published on August 14th, I want to talk a little bit about them because I know that the folks in immigrant families who might be calling you to ask about that letter they got will have questions about what the new rules say and how they could potentially apply to their immigration cases in the future. So I think the first really important thing to say is what the rules don't do. The new rule does not even try and cannot on its own change the people who are subject to and exempt from the public charge grounds of inadmissibility. So those first few slides where we talked about refugees and asylees and VAWA petitioners and UNT visa holders and special immigrant juvenile status, all of those people are all of those exemptions are gonna stay in place. The new rules do not and cannot change that. What the new rule does try to do is change the definition of public charge. So the new rule, if it ever takes effect, would expand the definition of public charge to mean anybody who is more likely than not to use any of these benefits listed here for 12 months or more over any 36-month period. So the benefits implicated include cash assistance, which we already have under current policy. It adds federal medical assistance. So this is just the regular medical assistance that people use to go see the doctor and get medicine. So that is included with some really important exceptions for emergency medical assistance and medical assistance for kids and medical assistance for pregnant adults. It's also important to note that it's just federal medical assistance. It's not state-funded medical assistance. State-funded medical assistance, general assistance, medical assistance, medically needy only, state-funded medical assistance, receipt of that would still be fine. Under the new rule, if it ever takes effect, people would be safe to continue to get medical assistance in any of those categories. The new rule would add food stamps to the list of implicated benefits, and then also housing subsidies and public housing. The new rule, if it ever takes effect, is very clear that an immigrant family member's receipt of benefits will not be considered at all, and that includes kids. And in this respect, the new rule is actually a little tiny bit better than the current policy that we have, because you remember that the current policy says that as a general rule, family members' benefits cannot be considered, with that one exception for family members who are receiving cash assistance when the family is using that cash benefit as the sole source of income for the family. So under the new rule, not even that could be considered. Family members' receipt of benefits just is not considered at all under the new rule, if it ever takes effect. No benefits besides those explicitly listed will be considered. So anything we didn't talk about, right, in that slide, anything that is not cash assistance, federal medical assistance, food stamps, or housing subsidies, public housing, anything besides that cannot be considered, right? So I've listed some really important ones here because these are all benefits that immigrants with some public charge risk can receive, right? So WIC is available to folks regardless of immigration status, earned income tax credit, unemployment compensation, workers' compensation, school lunch, marketplace subsidies, CHIP, charity care, and all of those things. None of those things can be considered during a public charge determination under the new rule if it ever takes effect. The new rule is also very clear that it will not be retroactively applied. So even if the lawsuits fail and the new rules take effect at that time, at the time that the lawsuits fail, a person's receipt of benefits now or at any point before the new rule takes effect cannot be counted against them during a public charge test. The new rules can only ever be applied to green card applications and visa renewals submitted after the new rule takes effect, right? So there is no retroactive application risk here. Totality of the circumstances is still the rule, right? Just like it is today, it will continue to be under the new rule. So past public benefits receipt alone cannot automatically make someone a public charge. All right. So Kelly, do we have any more questions before I move on to the case examples?
No, we don't have any new questions right now.
All right. So I'm going to move on to the case examples, which I find really help people think this stuff through because it's a lot of information and it's pretty confusing. If you have more questions, please feel free to ask them. So the first case example is Susanna. She has been living in the U.S. with temporary protective status since 2010. In 2014, she met and married a U.S. citizen, and they now have 2 U.S. citizen children. She and her husband work and earn about $3,000 a month, putting them at around 145% of the federal poverty level. Her husband and children receive SNAP or food stamps. Her children receive medical assistance, WIC, and child care subsidies. She and her husband receive marketplace subsidies. She received TANE when she was pregnant with her first child, and medical assistance when she was pregnant with her second. In 2015, her husband filed a petition and an affidavit of support for her immigrant visa and her green card. She received her green card in 2016, and now she wants to start the application process to become a U.S. citizen. So, Susanna is pretty typical of somebody who might have some concerns about public charge. And so the first question for Susanna is she subject to a future public charge test? Is there some, is there a step in her immigration case coming up where she's going to have to pass this public charge test? And the answer is no, right? So the next step for her, she already has her green card. Now she's thinking about applying for U.S. citizenship. The next step for her is going to be her U.S. citizenship application. And there is no public charge test during the U.S. citizenship application process. And this is pretty huge. I get this question a lot. People have this kind of, it seems, general misunderstanding that public charge is part of the U.S. citizenship application process, and it just isn't. So if that's the next step for people in their immigration case, they don't have a public charge problem coming up for them. But she might still think that she does, right? There is a lot of confusion and fear out there, and the confusion is understandable, right? These are really confusing ideas. And it's kind of mushing together 2 really confusing areas of the law, immigration law and public benefits law. So she might get caught up in that and think that she should be taking herself or her family off of benefits, but she should not, right? She should keep her benefits on and continue to apply for other benefits if she becomes eligible for them in the future. Sandra is a lot like Susanna. She also has been living in the U.S. with temporary protective status since 2010. She met and married a U.S. citizen in 2014. They have 2 U.S. citizen kids. They work and earn about $3,000 a month, putting them at around 145% of the federal poverty level. Her husband and children receive SNAP. Her children receive medical assistance, WIC, and child care subsidies. She and her husband receive marketplace subsidies. She received TANE when she was pregnant with her first child, and she received medical assistance when she was pregnant with her second. This is where things get a little different for Sandra. In August 2019, after hearing news that TPS for Sandra's country might be eliminated, she and her husband started looking into the process of filing a family petition and an affidavit of support for Sandra's immigrant visa and green card. And this, unfortunately, is a common situation for people with TPS. The Trump administration would like to eliminate many of the TPS designations that are in place currently. And people are very afraid because a lot of people have been here for a really long time and have built entire lives here in the US with their TPS status in place. And so Sandra is afraid, right? She wants to know how she can keep her family together in the US. And so she's starting to think about whether she should be applying for a green card through her husband, through her relationship with her spouse. So the first question for Sandra, is she subject to a future public charge test? And the answer for Sandra is yes, right? So unlike Susanna, who got her green card in the past, and she's had it for a few years, Sandra doesn't have it yet. She's still thinking about it. This is something she's going to be doing in the future, applying for her green card for her lawful permanent residency through her relationship with her spouse. And so because that'll be a family petition, the public charge test will apply to her when she goes to apply for that green card. What should she do? Well, this is the big question, right? The first thing she can do is talk with an immigration attorney about getting that green card application and affidavit of support filed as soon as possible, right? So if she can get it filed now, before the new rules that USCIS wants to put into place go into effect, then her green card application will be adjudicated under the current public charge policies, right? Yeah, and that's true even if she files her green card petition now, today, but the green card petition is not actually adjudicated until sometime after the new rules go into effect, if they ever go into effect, right? Just getting that green card application filed now makes her, gives her the ability to have that green card application adjudicated under the current USCIS public charge rules rather than the new rules, if they ever go into effect. So she should talk with an immigration lawyer about whether she can do that. But even if she can't, right, she should not be dropping her public benefits. Even if the lawsuits fail, and even if her green card application is filed after the new rules go into effect, her and her family's receipt of benefits will create no public charge risk, right? So remember, the new public charge rule does not consider family members' receipt of benefits, so there's no reason for her husband and kids not to get benefits. Nobody's getting cash assistance now, so nobody needs to think about whether that rule under current policy where, you know, cash assistance used as the family's sole source of income should apply here. And it wouldn't anyway, right, because they're both working. So it wouldn't be the family's sole source of income, even if they could get cash somehow. So there's no reason for her husband or her children to be dropping any of the benefits they're getting. The new public charge rule does not consider marketplace subsidies or WIC or child care subsidies, so there's no reason for anybody, including Sandra, to drop any of those things. Remember, Sandra is getting marketplace subsidies. There's no reason why she should be dropping those marketplace subsidies. The new public charge rule does not permit retroactive application. So her past receipt of medical assistance, remember she received medical assistance when she was pregnant, her past receipt of medical assistance can't be counted against her, even if she's applying for a green card after the new rules go into effect. It also wouldn't be counted against her because it was medical assistance for a pregnant woman, which is exempt under the new rule. And then she should also keep in mind that totality of the circumstances is the rule. So even though she did receive cash, right? She received TANF when she was pregnant with her first child, but it was a long time ago. Things are a lot different for her now. She's working. Her income, her family's income is over 125% of the federal poverty line, which is kind of this magic line that the new rule creates. If you have income under 125% of the federal poverty line, you get a negative mark, a mark against you and during the public charge test. So she's above that line, so she won't be getting that black mark during the public charge test. So she has some good things going for her, and so she with the help of a good immigration attorney, probably can make a good case here that she is not a public charge. Next is Sophia. Sophia also has been living in the U.S. with temporary protected status since 2010. She worked for several years, but was laid off in 2018. She received unemployment compensation for a little while, but that ran out in June 2019, which is also when she found out she's pregnant. She applied for and was approved for TANF in August 2019, not 2109. She also received medical assistance and WIC. Her boyfriend, Simon, is a U.S. citizen. They don't live together now, but they're planning to get married before the baby is due in February. He's working, and he earns enough to put himself at 220% of the federal poverty line, but once he gets married and the baby arrives, that income will put them at 130% of the federal poverty line. He currently receives marketplace subsidies, but he'll probably become eligible for Medicaid and SNAP, so they're thinking about whether they should apply for him once they get married and the baby is born. Sophia also just heard news that TPS for her country might be eliminated, so she's looking into her options for filing a family petition through Simon for her immigrant visa and green card. So Sophia has a lot going on, and this is a complicated situation for her, especially considering all of the changes around public charge. So the first question is she subject to a future public charge test? Well, probably, right? If she does get married and she applies for that green card through Simon, she'll be subject to a future public charge test during that green card application process. If what she does instead is she just continues to renew her TPS instead of trying to get the green card through Simon, then she'll be exempt from public charge, right? Because remember, there's no public charge test for TPS renewals. But if she wants to be safe, right, and make sure that she can stay in the U.S. Regardless of what happens with her TPS status, then she'll want to try to get her green card through this spousal relationship she has with Simon. So she should also talk with an immigration lawyer, right? She has a lot to talk about with an immigration lawyer. She should get that petition filed as soon as possible if she can. And she can think about dropping TANF, right? Because TANF is the one benefit she's getting that creates public charge risk under the current policy. But besides TANF, there is no other benefit that she should drop or forgo, right? She should keep everything else. And that's because the new public charge rule does not consider her family members' receipt of benefits, so there's no reason for Simon to drop his marketplace subsidies or to forgo Medicaid or SNAP if he becomes eligible. There's also no reason for the baby to forgo anything that the baby will be eligible for once the baby is born. The new public charge rule does not consider receipt of anything besides Sophia's receipt of food stamps, medical assistance, cash assistance, or housing subsidies, so there's no reason for Sophia to drop the WIC that she's currently receiving. The new public charge rule does not permit retroactive application, so her current receipt of medical assistance cannot be counted against her. It also cannot be counted against her because it's medical assistance for a pregnant woman, so there's no reason for her to drop her medical assistance. And she should also keep in mind that totality of the circumstances is the rule. If she gets married for Simon, which is the only way she's going to become eligible for a green card, right, through her spousal relationship with him, her family's income is going to go up. She'll become ineligible for TANF, you know, as a result. And her receipt of TANF will be a past receipt of TANF, right? It'll be in the past. It won't be current receipt of TANF. And that past receipt of TANF alone cannot make her a public charge. And she has some. She'll have some good things going for her through her family's total income and her past work history and all of that. That will be weighed positively in her favor. Sarah is a little more straightforward than Sophia. Her immigration case is a little more familiar, I think, to all of us. Sarah came to the U.S. on a temporary visa in January. She applied for asylum soon after arriving, and after 4 long years, her asylum application was finally approved in 2018. Now she wants to apply for a green card. She's been receiving SSI, SNAP or food stamps, and medical assistance since June 2019. So the first question for Sarah, just like our first 3 case examples, is she subject to a future public charge test? Well, she's going to be applying for that green card, right? But she's an asylee, so she will be exempt from the public charge grounds of inadmissibility when she goes to apply for that green card. So there's no public charge test coming up for Sarah during her green card application process. And then once she gets her green card, the next step will be potentially applying for U.S. citizenship. And there's no public charge test for anybody who during the U.S. citizenship application process. So Sarah doesn't have a public charge test coming up in her future. But she might think that she does, right? This is especially confusing, I think, for people who are getting cash assistance, right? Sarah is getting SSI, and SSI is one of those benefits that we have known since 1999 creates public charge risk for people. And it's one of the benefits that could potentially, you know, that's still implicated under current public charge policy as it exists today. But Sarah doesn't have to worry because she is exempt from public charge, so her receipt of SSI can't have any negative impact on her immigration case. So she should keep her benefits on. There's no reason for her to be dropping anything. Last case example is Sylvia and Samuel. They came to the U.S. on a tourist visa that has expired in 2014. They are now living in the U.S. They have 2 U.S. citizen children. They live here, they work here. Their kids receive food stamps, medical assistance, and childcare subsidies. Are Sylvia and Samuel subject to a future public charge test? This is a tough one, right? Because people without status always really want to hold out hope and believe that they have some shot at a green card in their future. But unfortunately for most people, they don't. There aren't very many ways for people who are living in the U.S. undocumented to be able to become eligible for a visa or a green card. If Sylvia and Samuel don't have a path to a green card, then they have no public charge test coming up for them. So it's a little bit of kind of good news, bad news potentially there for them, right? You don't have a public charge problem, but that is because you probably also don't have an option for getting a green card. So what should they do? Well, they can talk with an immigration attorney, right, to find out if maybe they do have a green card option. But even if they do have a green card option, they should keep their benefits on, right? Even if they become eligible for a visa or a green card in the future, and that path that they end up on to the visa or the green card will include a public charge test, there are no benefits that they or their children can get that will increase their public charge risk under the new USCIS rule. So family members' receipt of benefits isn't counted under the new rule. So their children's receipt of benefits cannot be, their children's receipt of food stamps and medical assistance and childcare subsidy cannot be counted against them. And the new rule, if it ever takes effect, considers none of the benefits that are available to people without status. So the only benefits that people who are undocumented can get are benefits that are not implicated under the public charge rules. So the new rule does not consider emergency medical assistance, WIC, charity care, services like medical care at a federally qualified health center, or food at pantries, food cupboards. So there's no reason for Sylvia or Samuel not to forego any of those benefits if they become eligible for them. Kelly, did you want to jump in there?
Yes, I am going to launch the second of the CLE credit polls. If you are requesting a CLE credit for your participation, please respond to this now. And also, we don't have any new questions. So okay. If you have any questions for Maripat, please enter them in the chat box now. We'll give it just a few seconds here, see if anybody gets anything typed in. Anybody have any questions? Oh, I'm not seeing anything come up, Maripat.
Great, thank you.
Thank you very much for presenting this webinar for us today, and have a great rest of the day.
Kelly.
Yeah?
Can I have like a couple more slides I just want to get to. I know we only have 3 minutes, but
yeah, no problem. Sorry about that.
No, that's okay. And I know we only have 3 more minutes, so I am going to kind of skip to these key takeaways. So I just want to reiterate that almost everyone who is eligible to receive public benefits can receive those without public charge risk. People should not be disenrolling from benefits. At the very least, they should be talking with an expert before they decide to forego benefits they're eligible for. If you're working with families who are applying for visas from overseas or helping people immigrate from overseas, they need to talk with an immigration attorney. The Department of State process, like I said, is a lot different than what's happening here in the US. People who are thinking about applying for family-based immigration should do so as soon as possible. Low-income green card holders, if they can, just don't travel outside the US for 6 months or more. And if they have to, they should talk with an immigration attorney before leaving. We didn't talk about public charge deportation today, but it is a thing. Public charge deportation exists, but the test for that is extremely, extremely restrictive, and it applies to virtually no one. There have been, I think, maybe from what I hear from immigration experts, something like 2 deportations on public charge grounds over the last 100 years or so. It is extremely rare. People should not be afraid of that, of public charge deportation. And then, of course, advocates are fighting hard. These 9 lawsuits will continue, so stay tuned for updates on that litigation. If folks are looking for additional resources, the Protecting Immigrant Families campaign has really great resources, and that is a joint campaign between the National Immigration Law Center and the Center on Law and Social Policy. PIC, the Pennsylvania Immigration and Citizenship Coalition, has a webpage devoted to public charge where a lot of CLS's materials are posted. So check out those sites for resources and also updates on the litigation as it continues. And I did want to just flash this for people. This is the letter that the Department of Human Services sent out to folks. So if folks haven't seen it yet, I wanted to be sure people know what it looks like. So if folks present it to you, you can recognize it. So that's it. Thank you, everybody.
Thank you. Have a great day.